Okay, well, can everyone hear me?
I can hear you.
Okay, I don't know what's going on with the live on YouTube, but I'm sorry. I guess they can't fire me, I guess. I
That's your fault.
Yeah, I don't know when she's coming back there. I'm
I
gonna be
don't know.
honest. She seemed
I'm
just
about to
as
move
confused as
on.
the one from
IT is
yesterday.
working on it, but I'm gonna keep going.
Yep.
All right, what's next? What's ready next, Madam Clerk?
All right, I see Miss Casca there. I don't know if Nora is on the screen. Is
He
Nora available?
is actually.
Yeah, I'm here, Your Honor.
What about the prosecutor?
I'm here.
Okay. All right, we're on the record with the matter of People versus Shabir Noor. Mr. Noor is here on cases 21-41301FH and 21-138001FH for a final conference on each file. Appearances, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
And good morning, Your Honor. May it please this most honorable court. Nicole Casta,
Ms. Cass, Miss Casca,
on behalf of,
Miss Casca,
yes,
we can't. You're going
Yes.
in and out. You gotta do something because we can't understand. You're going in and out every other word.
okay, I'm sorry, I'm on an older device, so,
Is it the headphones? Can you use something else besides the headphones?
no, that's actually for another device. I'm actually using speaker on the computer.
Okay, that's a
If
little
you
bit.
want me to, I can just log off and go on my phone.
Yes, why don't you do that?
Okay, thank you. Sorry for the disruption.
No problem. Oh, yeah, just pass it until she gets back on. Just call something else.
Okay, who's ready?
Ready on Patel, Your Honor.
Patel.
People are ready on Octavia Hall. Good morning, Cam Towns.
Good morning, Mr. Towns.
Good morning, Judge Baker.
For the Patel
Patel.
final conference, okay. All right, for the record, calling people versus Samit Patel. This is case 21-108701FH. Matter before the court is a final conference. Appearances, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Good morning, Your Honor. Attorney Michael Kelly, P77187, on behalf of Samit Patel.
Good morning. Where's Patel?
Good morning.
Please state your name for the record.
Samit R. Patel.
All right, good morning, Mr. Patel. What
Good
are we
morning.
doing on this case? Is there an offer from the people?
Yes, Judge, there is an offer. The final offer was relayed by my docket attorney to Mr. Kelly on April 28, 2021. The offer would be to plead guilty to count 1, operating while intoxicated. That's a 93-day misdemeanor. It would include the third offense notice felony, which makes it a 5-year maximum felony. The people would withdraw the habitual offender third offense notice in exchange for a plea of guilty on the operating while intoxicated felony. The sentence agreement would be 2 years probation with the first 6 months in the Wayne County Jail.
Okay,
Yes, Your Honor.
Is that the first time you're hearing that offer, Mr. Kelly?
No, it's not. That's correct, Your Honor. I have received previously at our last, I believe there was a different judge covering for you last time when I received that offer. I did discuss same with my client. I had requested from the prosecutor their consideration and acquiescence for a Cobb's agreement with Your Honor. I would be asking for a Cobb's evaluation at this time, Your Honor.
All right. What I want you to do is submit a Cobb's memo. Did you do that?
I did to the prosecutor, Your Honor, but I did not to yourself.
Okay. Submit the Cobb's memo to the court. And then on the next hearing, the court will give you a Cobb. So How many matters do we have on the 11th
20,
and the 4th?
7.
Oh, that's right, because I have a hearing on the 4th. Okay, June 11th. Pre-trial June 11th. Make sure I get the cons memo.
Will do, Your Honor.
All right, anything else further from the parties?
No, Your Honor.
No,
No.
Judge. Thank you.
All right, this matter is concluded. Mr. Patel, you're concluded. Have a nice day.
Thank you,
Thanks, Your
Judge.
Honor.
Okay, I think Ms. Casca is back.
All right, want to try that again.
Yes.
I am, Judge. I actually signed out on another device and came into your courtroom.
That's much better.
Okay,
Yeah.
recalling the matter of People versus Shabir Noor, cases 21-413 and 21-1380 for final conference. Appearances, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
And good morning, Your Honor. May it please this most honorable court, Nicole Casca, P55470, appearing on behalf of Mr. Noor. Your Honor, both Mr. Noor and myself are appearing by Zoom video as opposed to physically in person in the courtroom. We are consenting to having this hearing conducted by Zoom video. Mr. Noor, can you please state your full name for the record and whether or not you consent to having this hearing conducted by Zoom?
Yes, Shabir Noor, and I consent.
Okay, good morning, Mr. Noor, and to Ms. Casca.
Good morning,
Ms.
Your Honor.
McCray, do we have an offer from the people?
We do, Judge. We were trying to get this into drug court, and I received information from the coordinator, Ms. Bradley, that said she had made several attempts and calls to the defendant on March 26th, April 1st, and April 8th of this year and hadn't heard back. But then I think she might have spoke. So there is an offer, Judge, but I think we're trying to pursue drug court in this case. And so the defendant just needs to fill out all the paperwork so that he can be screened properly for drug court.
Yeah, I
Casca,
received.
what's going on with your, hold on, Mr. Noor, with your client getting the paperwork in for drug court?
Your Honor, I don't know that, I just found out that there was a problem as of today with him not being able to go and submit the paperwork. I have not heard anything to the contrary. I provided all of his contact information, including his phone number, and I did not know that there was, I think there was some problem with a printer or something, but Mr. Noor never reached back out to me in order to be able to work something out.
Okay, so Mr. Noor, what's the issue with you getting the information into drug court?
Yeah, I received the paperwork and my she emailed it to me just 2 days ago. I haven't used my printer in quite some time, so I didn't know that. I don't know if it ran out of ink or what, but I just got the papers 2 days ago.
That's because they couldn't get in touch with you the previous days.
The drug court officer contacted me Wednesday afternoon around like 4 p.m. She stated that she called me 3 weeks prior to that, but I wasn't aware of any phone call.
Okay, all right, well, you now have it, you're now on notice. So whether your
Yeah,
printer
I'll
works-
have it into them. I ordered a new printer, which should be here by today afternoon. So I should have it to them by the end of today or by tomorrow morning.
or by Monday. Mr. Noor, if your printer doesn't come in, simply go to Kinko's and have it printed out.
Yep, I will.
Okay? All right, I'm gonna give you a new date, so this does not fall into the cracks.
Mhm.
You want to use the 18th, Your Honor, or the
Yes.
25th of,
The 18th.
okay. June 18th?
That will be fine, Judge. If I'm in a jury trial in Macomb Circuit, which I don't know if it's really going, because whether they've been approved, I will make sure that I have somebody to stand in and have all the information to the court.
Okay, thank you, Ms. Costa. All right, this matter is concluded.
Thank you very much, Judge, and I'll make sure I follow up with Mr. Noor to make sure that we get that paperwork to drug court over at least at the latest Monday.
Okay,
Thank you, Your Honor.
Okay, thank you, everybody. Continue to be safe and be healthy.
all right, let's do Mr. Hall.
All right, parties on Octavia Hall. This is case 18-1384-01FC, People versus Octavia Hall. This is the date and time scheduled for sentencing. Appearances, please.
Good morning, Your Honor. Cam Towns, Assistant Prosecutor on behalf of the people, P45518, Your Honor.
Good morning.
Morning. Good morning, Your Honor. Christine Pajak, State Appellate Defender Office, on behalf of Mr. Hall. P67095 with me is Monique Dake, who submitted a letter to the court on behalf of Mr. Hall, and Mr. Hall, who is present via Zoom.
All right, good morning. Mr. Hall, state your name for the record.
Octavius Hall.
All right, and Ms. Dake,
Miss Dake, Monique Dake. Good morning, Your Honor.
good morning. All right, this is the date, time, and place set for sentencing in this matter. First off, Mr. Hall, do you agree to be sentenced over Zoom?
Yes, ma'am.
Okay. All right, so this court received a Court of Appeals, Michigan Court of Appeals decision, which reversed 2 of the counts, which would have required Mr. Hall to be retried. And the last time we were here, there was an agreement entered into by the parties in lieu of there being a new trial. The court has reviewed the pre-sentence investigation report. Have the parties reviewed the pre-sentence investigation report?
I have, Your Honor.
Yes, Judge, the people have as well. There's one thing I wanted to draw to the court's attention, though. We received an email yesterday from Hope Canada, which I believe is your clerk or legal research. And the email indicated that the court didn't have a signed plea form for Mr. Hall.
No, she replied back, we could not find the settlement offer advice of rights notice of acceptance. You know, they're rotating clerks. My clerk is out on medical, and so we could not find it, but there was a separate file that didn't have the court's orders and things, and it was a separate file that just had some other information like case law, cases, and other things that had happened on this case. And that's where the settlement offer advice of rights notice of acceptance was. So I told her to email the parties back and tell her that the court did have it, but it was not scanned in. This clerk had to scan it in this morning. So unfortunately, the rotation of clerks, things aren't always done.
Yes, thank you, Judge. I just want to make sure that was clear for the record that there is a signed settlement and offer form.
Oh, and I did not receive that email, so I just learned about it now.
Oh, you didn't? Oh,
I
okay.
did not. I don't know which, I don't know where the email went, but it sounds like the problem is solved, so that's
It
just
is.
as well.
Thank you.
All right, have the parties had an opportunity to review? You said you did, so are there corrections, deletions, or additions to the body of the report?
I have a correction under evaluation and plan, page 1. And I think Ms. Towns would agree with me that the agreement is not correctly listed in there. There's a couple of mistakes. So if you look at about midway down the paragraph that starts on 4/21/2020, so that's page 1, it should say that the plea was to
Wait, this says on 4/20, okay, so on 4/21/2021.
right.
Okay,
And
Go
then
ahead.
you see where it says he pled guilty to firearms discharged from a motor vehicle causing serious impairment. It should say causing injury.
That is correct. I agree with that.
And,
make the change.
okay. Thank you. And then in the next paragraph, it says that he agreed to, agreed to serve 16 to 15 years. With respect to the GBH charge, that should say 6 to 15.
That is correct, Your Honor.
Right, the court is making that change. as
Did
well.
Mr. Hall place his appearance on the record and agree to appear via Zoom?
He already did.
Yes, ma'am.
Okay, thank you.
Okay, go ahead. Anything else?
Those were the mistakes I noticed.
Ms. Towns, any additions, corrections, or deletions?
No, Your Honor, thank you.
Well, the court noticed some,
Oh.
so, the plea agreement says count 2, which is 5.5 to 22. That's for the weapons, firearm discharged from a vehicle causing injury, correct?
Yes.
However, under current convictions, it's listed as charge 9. And when I looked at that was charge 2, wasn't it?
I believe
Yes.
that is
Yeah.
count 2.
That should be 2, as well as the weapons felony firearm associated with that should be 6 and not 8, because that's what's also on this plea agreement, 2 years MDOC. The count 3, which was the GBH, the 6 to 15 on the associated pre-sentence investigation report, they have that as count 6. It should be 3. As well as the weapons carrying concealed is not charge 7, it's 4. Habitual second, which is what the jury found him guilty of. Same thing with count 3. As well as he was found guilty of charge 7 under weapons felony firearm, which was the 2 years. And the reason it stuck out to me is because in the plea agreement, it specifically says count 7 is not an issue and original sentence remains, and counts 1 and 5 are not guilty by jury. And I'm thinking, okay, well, that's the case. These numbers don't match up. So those have to be changed so I made those changes. Are there any objections by the parties?
No, Your Honor, I would just indicate on the front cover page where it says plea agreement and then it says
Yes.
sentence agreement, everything is listed properly on the front page after plea agreement.
It is. That's why I was able to follow and find out that those charge numbers were incorrect.
Yes,
So-
people have no objection to the court's corrections. Thank you.
My name is misspelled, but I'm used to that, so.
Oh,
But if
okay.
you're-
What should that? Give me the correct spelling.
It should be PAGAC, not R.
Okay, I made that correction too. Okay. Any other corrections to the body of the report?
None from the people, Your Honor. Thank you.
Your Honor,
Alright.
thank you.
Now, let's go to guidelines. Why do I have 2? I don't know why. I guess we have 2 because one was a jury and one was a plea. The guidelines that I have are connected to the pre-sentence investigation report with respect to the jury convictions. I'm showing under assault with intent to do great bodily harm less than murder, the guidelines are 34 to 83.
I am
Correct.
looking at the guidelines that are attached to the discharge from a motor vehicle causing a serious injury.
So I have a corrected one that has the discharge causing injury.
Yes, there are
That
2
was-
pre-sentence investigation reports. You all don't have both?
I
There's
have the
2.
one, Your Honor, I only have the one where the range is 50 to 125 months, and that's the discharge causing injury.
Okay, there's another pre-sentence report that they redid with respect to the jury convictions. You all should have both. They both have sentence date up to, well, one has the date from April the 21st, 2021.
I have the one that was sent before our last hearing.
Mhm.
And then I also got one yesterday. Well, I got one a couple of days ago that had the serious impairment score, and I asked them if they could score the guidelines for injury, and I thought I had seen corrected guidelines for the GBH the last time as well.
All right, well, we have to, because he's being Well, he's taken a plea, but I believe we still have to go over, since they did do another pre-sentence report with respect to his jury conviction, we're still gonna have to address that PSI as well, which is dated 4/21.
I'm sorry, Your Honor. A garbage truck pulled up just as you were speaking, so.
I'm sorry.
That's, so you said we need to, I think I just missed what you said the guidelines were for the GBH charge.
All right, let me indicate that there are two pre-sentence investigation reports. One was with respect to the jury convictions, which was dated originally April 21st, 2021. And I'm actually about to change that date to today's date. And then there is also a pre-sentence report as with respect to the new plea to the two charges that he could have had a new trial on. So all parties should have both pre-sentence investigation reports because he has to be resentenced on all of it, correct?
Yes, Your Honor.
Yes, Judge, that's correct.
If you all don't have both, then Ms. Schoen is gonna have to send you the other pre-sentence investigation report because we need to all make sure we have the same reports and the same guidelines. So let Ms. Schoen know in the chat if you do not have the pre-sentence investigation report with respect to the jury trial. And make sure you have guidelines. I have the one with respect to the jury trial and the guidelines are for the assault with intent to do great bodily harm, less than murder. They only
I have those. I'm sorry. I have those as well, Your Honor.
I have those as well too, Judge. I think we have the GBH guidelines from before, and the guidelines that just came recently are the discharge causing injury.
Correct. So that one was on the previous pre-sentence. That's what I was asking if you all had that. Okay.
Yes.
And then the guidelines on the current one, which let me see. I don't know if they attached the guidelines to my copy. Okay. So, and then I don't know, it's my guidelines. I'm not sure they attached the guidelines to my copy on the discharge from a vehicle causing injury.
Under investigation right now. We can investigate over the phone.
All right, I have it. All right, so the guidelines under the PSI regarding discharge from a vehicle causing injury, I have 50 to 125. Is that correct?
That is correct, Your Honor.
Yes, Your Honor.
Okay. And then with respect to the GBH, I have that the guidelines are 34 to 83. Is that correct?
That's correct, Your Honor.
Yes, Your Honor.
Okay. All right, is there anything further from the people on this case?
No, Your Honor, the people are just asking that you enforce the sentence agreement that's listed in its totality on the first page of the pre-sentence report for the discharge causing injury. And it's laid out pretty clearly. So we ask that you enforce that sentence agreement, Your Honor. Thank you.
Okay. Defense?
We're also asking the court to abide by the sentence agreement in total for the counts, as the prosecutor did. Thank you, Your Honor.
Okay. Mr. Hall, is there anything you'd like to say before the court imposes sentence?
Yes, I was just wanted to apologize to not only the court, prosecutors, and the victim, but I've completed a lot of core programming since I've been incarcerated. And I've also contracted coronavirus, even though I got over it, it's still circulating through my facility. And I was just wondering, with respects to the prosecutor, if it was any possible way that I can get an alternative incarceration, and I'm willing to accept any stipulations that may impose for me, and I'll promise to comply by them if it's possible.
Judge, the people are seeking to enforce a sentence agreement which requires MDOC time, we are not interested in any alternative incarceration.
Yes, ma'am.
All right, Mr. Hall, this is a sentence agreement entered into by the people and the defense, and so the court, the court can't make any changes. It's a sentence agreement with respect to them outside of the court, not accepting it, and then you happen to basically re-plead, and so I'm not sure you're not trying to do that.
No,
Ms.
ma'am.
Day, is there a reason why you're on the call?
I'm the mitigation specialist who submitted the letter on behalf of Mr. Hall.
Okay, but you are aware that there was a sentence agreement, right?
Yes, ma'am.
Okay. Okay. The court is going to adopt the sentence agreement entered into by the parties. And per that sentence agreement, Mr. Hall is sentenced to count 2, weapons, firearms discharged from a vehicle causing injury, habitual criminal second offense notice, 5.5 to 22.5 years. There is jail credit of 703 days. Is that still correct?
Well, let's see. It should be, it's 1433 total days credit. But it's consecutive to the 2 years, so.
Right. So let me know if it's not correct, let me know. The court will make
I
a
will,
change.
I'm gonna do some math while we're doing this, so.
All right, well, I'll proceed and you can let me know if the jail credit has changed. As to count 6 is the 2 years in the Michigan Department of Corrections, which is to be served consecutive to the to count 2, as well as the other counts that are not felony firearm. Count 3, assault with intent to do great bodily harm, less than murder, is 6 years to 15 years in the Michigan Department of Corrections. That is to run concurrent with count 2 and consecutive to count 6. Count 4, carrying a concealed weapon, 32 years to 7.5 years, Michigan Department of Corrections. 32 months, to 7.5 years, the Michigan Department of Corrections. That will also run concurrent to counts 2 and 3. And actually, the CCW, isn't the CCW run concurrent to the felony firearm?
Yes, Your Honor.
Judge, it does.
Okay, so I run as well as concurrent with the felony firearm. It'll be, and
No, Judge, I'm sorry, the CCW doesn't run along with the felony firearm.
so it's still consecutive to the felony firearm.
Correct. CCW and the felony firearm do not run concurrent with each other. Felony firearm does not run concurrent with anything in this
All right,
case.
so the carrying concealed weapon will run concurrent with counts 2 and 3 and
Yes.
consecutive to count 6.
Yes.
Count 7 is also the weapons carrying concealed. That was a part of the original sentence and remains intact. I believe that has already been served, the 2 years. And counts 1 and 5 were not guilty by jury decision. Is that correct?
That is correct, Your Honor.
Okay.
The discharge from motor vehicle, the CCW, and the assault with intent to do great bodily harm all run concurrent with each other, and they
Right.
run consecutive to the felony firearm count.
Correct. All
Thank you,
right.
Judge.
Do we have a jail credit now, Miss?
Paycheck, thank you.
Yes, no, I didn't want to pronounce it incorrectly.
You would not be the first to pronounce it incorrectly, Your Honor. You'll be shocked to learn that that's the case. I have, if it's 1433 minus 730, it's 2 years is 730. So if you said 703, I think the first time.
Yes. No, I said 730 is the jail credit.
Then I need to I think 700, okay, then my math is probably wrong.
Okay, 730 days jail credit. You must not have verbal, written, electronic, or physical contact with Leon McCray, either directly or through another person. And you must not be within 500 feet of the residence, school, or place of employment. You must pay $340 state costs ordered by the court, and $130 crime victims assessment. You must pay court costs, $1,300 is ordered by the court. Okay, I'm gonna waive that. Mr. And then there are attorney fees for $400.
Those weren't assessed before, Judge?
Pardon me?
Were those assessed before? When he was
The 1,300?
any court cost?
Oh, I don't know. You're indicating, because if they were assessed before, it would be a double.
Right.
Okay, I don't know, because this was done back in, how long ago was this? I have no clue. Is there a way for you to find out? I will
Is it
indicate
possible
that if these costs were assessed before, that we are not assessing the costs again. So all of these costs will be waived if they were already assessed before and he's already paid those costs. Okay?
Okay, can I have is it possible if I can have clarity on my time credited?
Yes, your time credited is, your jail credit days is 730 on
For the
these.
felony. I've already completed my felony. I'm
Yes, you
actually,
already completed the felony firearm. And there's 730 days jail credit on the remaining count.
towards the 6 years, 6 to 15 years,
Correct.
towards the AGBH.
Correct.
Okay.
Is that correct, counsel?
I believe so.
Well, we want to be sure now.
It's the credit that was we were talking about. Yes, it is correct.
Okay. 730 days, Mr. Hall, okay? That's your credit.
Okay.
All right, because the felony firearm had to be served first. So that was taken out.
Well, right. So 730, the 2 years credit already for the felony firearm plus the 730. I think that's the clarity Mr. Hall is looking for.
I'm sorry.
So it would say 1433 total credit on the judgment of sentence,
Right.
and then
1433 is the total.
Right.
The 2 years has already been served. So what the 730 is the credit he has for the other count.
Correct. Yes, that's
Even though
it's
showing,
yeah.
though it is showing 730 on the felony firearm, but okay. It is my duty to advise you that you have a right to request leave to appeal for the Court of Appeals to appeal your plea and sentence. If you are unable to afford an attorney to prepare the post-conviction motion or perfect an appeal, this court will appoint an attorney for you at public expense and will provide that attorney with such portion of the transcript as that attorney may require to prepare a motion or an appeal. You are further advised that if you wish to file an appeal or a motion, the request for an appointment of an attorney must be made in writing and filed with the clerk of this court within 42 days of today's date. Because we are on Zoom, the clerk will email the advice of rights, appellate rights form to your attorney. We'll forward it to you. Does your attorney have permission to initial the form on your behalf, acknowledging your receipt of the form?
Yes, ma'am.
Okay. This is the form that you will file with the clerk of this court within 42 days of today's date if you wish to appeal and need to have counsel appointed for you. If you do not wish to appeal, you do not need to send that in. All right. So you are already awarded the Michigan Department of Corrections, so I don't need to remand you to that. Believe that's it. Anything else from the parties?
Nothing from people, Your Honor. Thank you very much.
Thank you, Your Honor.
Thank you. All right,
Stay
Mr.
healthy,
Hall,
everyone.
good luck to you.
All right, thank you.
Okay.
There's a whole lot going on.
It was a lot.
So here is Mr. Washington.
Are we ready on his case?
Yeah, Judge, let me see, I'm putting final conference date at 7/7. I don't know if you want that different. I didn't put it on the form, I just put it here.
Okay.
All right. Are you ready, Mr. Washington?
Yes,
Is that Mr. Ware?
I believe it is. It says Livingston County. Yeah, I believe that is Mr. Ware.
Okay, and the prosecutor, I think it's Miss McCray.
Yes.
Record calling People versus Kelvin Marlowe Ware. This is case 21-207801FH. This is the date and time scheduled for a calendar conference. Appearances, please.
Good morning, Your Honor. Andrea McCray, appearing on behalf of the people, P number 83698.
Good morning, Your Honor. Earl Washington, Neighborhood Defender Services of Detroit, 31383, on behalf of Mr. Calvin Ware.
All right, good morning, Mr. Washington. Mr. Ware, state your name for the record.
Calvin Marlowe Ware.
All right, is there an offer from the people?
Yes, Judge, there is an offer. It was conveyed to Brother Counsel on May 3rd. The offer would be to plead guilty to the reduced count 1 of attempt carrying a concealed weapon. The attempt makes it a 2.5-year felony. It would be a plea to fleeing, count 2, police officer fleeing, but we would reduce that count to 2nd degree. So it would be fleeing in the 2nd degree for the vehicle code. I think that's a 5-year felony, but I'm not positive. And it would be a plea to the count 4 weapons felony firearm count that carries a mandatory 2 years consecutive prison sentence to any other sentence. We would agree to dismiss count 3, and we would withdraw the habitual offender second offense notice. There would be no sentence agreement. It would be left up to Your Honor.
What is that feedback I'm getting? Who is that?
I think that's where the defendant is located, Your Honor.
Oh, okay. With respect to count 2, we need to know what the tail is on that because the defendant needs to be advised of that.
Yes, Your Honor. I'm looking it up right now. I apologize.
No, that wouldn't. She's looking for the tail on count 2 to reduce count 2. Make it a 2nd instead of a 3rd.
Okay, Judge, I believe it says under MCL 750.479A 4, I'm reading, an individual who violates subsection 1 is guilty of 2nd degree fleeing and eluding, a felony punishable by imprisonment for not more than 10 years or a fine not more than $10,000. So the 2nd degree would be a 10-year felony.
A 10-year?
Yeah, I'm not, and I don't, I'm sorry, Judge, I don't think this is right because I don't know
it
how
can't be right. That's more than the original charge.
Right. So I don't think that's right. Because you can't just increase the charge.
All right, let me give you all some dates because we need to get that together. The defendant needs to be apprised of what it is he's looking at. And that can't be it. So the transcript should be in. It was due in April 7th.
It's available.
Okay, so it's available. Mr. Washington, are you planning on filing any motions in this matter?
Judge, I'm not sure. I need to look over some things. It's a possibility. It's a possible there may be some motions filed.
Okay. I think we need to just take breaks once we speak because of that background. All right, so any motions must be time stamped and filed by. Yeah, I'm gonna change it. Okay. It's been in there. June 11th. Any responses are due by June 18th. How many matters do we have on June 25?
You good on it. June 25, you have 10.
Okay. Final conference will be on June 25th. And any motions timely filed will be heard on June 25th. So the court is signing the calendar conference as well as the reciprocal order discovery, which will be sent to the parties. And hope you all, I'm sure you'll talk and make sure you talk and try to get the offer together. Make sure everybody's aware of what the offer should be. Okay?
Yes, and Your Honor, is it possible I can speak to Mr. Ware in a breakout room?
Yes. Hold on a second.
Thank you.
All right, you received a request.
Oh,
What is Mr. King?
Good morning. I heard my name.
Hi, Mr. King. What cases do you have?
I have Anthony Thomas.
Anthony Thomas. Let me look that up for you. I don't see it on the
Anthony
document.
Thomas. We don't
Right.
have that on the document.
Let me see if it was moved or something. What's the case number, Mr. King?
20 00468601.
Okay. That's on Judge Darnella Williams Claiborne's docket today.
That
At
would
10
be
o'clock.
why I have the wrong courtroom. Thank you. Sorry.
That's okay.
Is there somebody here to do the violator, or is the violator here? Mr. Page, I see he signed in.
Probation's here.
Right, he needs an attorney.
Who's house counsel?
Mr. Page,
Good morning, Mr. Page.
how you doing? Good morning.
You got a letter docket.
We need to get you house counsel. Hold on a second. Who is DeQuan Hall?
Mr. Hall needs a new date, Judge. It's a violator. We're tracking a new case.
All right, we can just call that.
Okay. I don't have any information on him, but okay, for the record, calling People versus DeQuan Hall, case 18-2843. This is the date and time scheduled for a violation hearing.
Appearances, okay, well, we don't have anybody here on behalf of Mr. Hall, but we're just tracking, correct?
That's correct, Judge. His next court date is 5/24/21.
Okay, so let's just set this for a date after 5/24/21 is for what proceeding?
That is going to be for a preliminary exam at 41B District Court.
Okay, good morning, Mr. Hall.
Good morning.
Mr. Hall, who is your attorney on your other case?
Mrs. Hold on one second. I gotta look.
Okay. Who is Tanya Lever? Oh, that's you. No, that's not you. You're Kristen.
I'm not on.
Who is Tanya Lever?
Her name is Irene.
That's her first name, Mr. Hall?
Yes, Irene.
What's her last name?
I don't know her last name. I just got a text message. It say I just got her name here is Irene. From
Okay,
Clinton.
we're gonna set this matter then after you have that matter, so we'll know where you are, okay?
Yes, ma'am.
So we'll make this June 25th
25th.
at 9
Okay.
o'clock.
Okay.
Mr. Hall?
Yes.
All right, see you back on June 25th at 9 o'clock.
Yes, ma'am. Good weekend.
You too. All right, so, oh, here you can have Mr. Williams. So we're back to Mr. Page, and we need to get house counsel on the line for Mr. Page. Who is Tanya Leverett?
Your Honor, I'm here for the Duke Billingsley case.
And that was put over.
No, it wasn't put over, but we didn't have anybody show up on it.
This is a trial readiness review.
Oh, okay, that's what, well, the attorneys haven't even shown up.
I know, Mr. Glenn, he's always.
Who are you with respect to the case, ma'am?
The victim.
Oh, okay.
The other thing to go in wasn't working, so I hope this is okay.
Okay, well, technically it's not supposed to be, but you're right. My understanding, I guess, is live is not showing, so that's fine. We need to get Mr. Glenn on the phone. Okay. We need to find out. Is that your case, Ms. McCray?
Judge, I'm sorry, I didn't hear what the name of the case was.
Duke Billingsley.
No, that is a domestic violence case, Darian Fortier.
Can you text them or email them, tell them that they need to come on and this case is up today?
Yes, Your Honor, I'll do that right now.
Thank you. All right, Mr. Washington, are you all done? You're on mute, Mr. Washington.
Yes, I'm all finished. Sorry about that. Yes. Okay. Thank you. And
have a good weekend.
Have a good weekend, Your Honor. Thank you.
All right. Bye-bye.
Bye.
All right, Mr. Ware, have a good weekend. You're concluded.
Good morning.
It's still on.
Judge Baker's courtroom.
You won't be in a minute.
Calling about the Duke Billingsley case that's up for a trial readiness review. It is today. That's Judge Baker. All right. Bye. Mr. Glenn's coming in.
All right, where's the file?
Judge Baker?
Yes.
For the record, for Mr. Page, there's two separate dockets with new there's allegations of new criminal activity that did not result in any type of case, for the record.
All right.
I got the two,
Well, hold on one second. We need to get House Counsel on for Mr. Page.
can you appoint Mr. Glenn when he comes in?
Yeah, I can. Yeah, probably need to
That's
talk to
IT.
Mr. Page. Ms. Joan, do you have some information on Mr. Page? Do we have information on Mr. Page?
I have just two warrants.
I forwarded 2 warrants to the Judge Baker email. There were new assaultive allegations that there's nothing new that resulted out of the allegations.
Okay, well, Mr. Glenn is coming on, so when Mr.
Okay.
Glenn gets on, how have you send it to Mr. Glenn? Is your recommendation to close this out?
No, Judge, actually, there's
Okay,
2.
well, never mind, stop. We'll wait till Mr. Glenn comes on then. We'll see if Mr. Glenn can represent Mr. Page. All right, all right, there's Mr. Glenn right there. We need to what? Okay, hold on one second. IT need us to take a quick break because I guess we're still not streaming. Hold on a second, Mr. Glenn. We also got to get your prosecutor on, Mr. Glenn, so hold on.
Judge, and I just spoke with the prosecutor assigned to the domestic violence Valencia matter. She said she is on the way to 36 District Court for an exam. And she said, let me see, will she let me pull over and do it in my car, or have someone from my unit stand in? Is the judge there?